this, that. Oh, is it this one? Even Ghanaian courts will close their eyes to this one. They will not invalidate the marriage because of this one. He is an expert in that area. And so you are calling him. Can somebody tell me the reason why you will not call the professor of the Ghanaian professor of Ghanaian conflict of laws? Can somebody tell me why you would need to call him as your expert?
Because we are applying Ghanaian internal laws, not Ghanaian conflict of laws, sir.
Okay, very well. Very well. Are we making progress? Can I move on?
Yes, sir. Please, if I may ask, sir, in such situation, are we rejecting Ruvwa, sir?
Of course, now I told you that the meaning when you choose the internal law of the Lex Corsia is that you are rejecting Ruvwa. The other word for it, the other phrase for it is that you are applying what is known as internal law theory. Internal law theory. That is everything about Ghana is its internal. You are closing your eyes to its external. You are closing your eyes to the Ghanaian rules that would have applied in circumstances where the marriage was done in Ghana by foreign elements. So it is called internal law theory. So that is the first theory of Ruvwa, internal law theory. The foreign court will just apply the internal law of the Lex Corsia, ignoring its conflict rules. Okay? The second meaning, the second practice of Ruvwa is when the foreign court says, well, but you know that this matter is a matter that has foreign element. The marriage was done in Ghana, no doubt, but there's a Nigerian domiciliary involved. So we would have loved to know what is going to be the Ghanaian approach in circumstances where there is a foreign element. When you now look at foreign law in that context, then you are not rejecting Ruvwa, you are accepting Ruvwa. Okay? What are you doing? You are accepting Ruvwa when you treat the Lex Corsia to mean the conflict rules of the Lex Corsia. That is, you are accepting Ruvwa. And when you do that, you have started a new problem. You have started an entirely new problem, the solution to which will also depend on the choices of your country, that is of the forum. Now, when you accept Ruvwa, there are two categories of acceptance of Ruvwa. There is a partial Ruvwa. That one is usually very easy to explain. But there is also another one, very difficult to explain, the one we call double Ruvwa or total Ruvwa. If you have a jotter and you are jotting, jot it. There is partial Ruvwa and there is total or double Ruvwa. There is partial or single Ruvwa. Partial or single Ruvwa. Then there is total or double Ruvwa. So let's start with partial or single Ruvwa. Partial or single Ruvwa. As I've explained, acceptance of Ruvwa simply means that you are treating Lex Corsia the Lex Corsia to be the conflict rules of the locus of the foreign law. Okay? You are treating it as the conflict rules of the locus of the foreign law and not its internal law. So what do we mean by that? Let's go back to the Ghanaian example. You know that our own conflict rules, when the question is as to form, is what? Lex loci celebratoris. Suppose Ghanaian conflict rule is not lex loci celebrationis. Suppose it is lex domicili. Suppose the Ghanaian conflict rules on the question of form. I'm just using it as an example. That's not the correct position. The correct position is that Ghana is also a common law country like us. They will apply the same lex loci celebrationis. But assuming they are not applying lex loci celebrationis, assuming they are applying lex domicili. So let's look at it. Let's go back to the question we asked. We said it's Ghanaian law. And internal law theory means apply Ghanaian Marriage Act. Okay? But now we are saying, no, we are accepting Ruvua. And we are saying that in Ghana, the conflict rules to determine the question whether a marriage was formally valid or not is lex domicili, the law of the place of domicile. So if we are accepting Ruvua partially, we are not going to go for Ghanaian Marriage Act. We are going to go for Ghanaian conflict rule. And Ghanaian conflict rule will tell us apply lex domicili, law of the place of domicile. And suppose the company we are domicile in Nigeria. What are you going to say? You are going to say that Ghana has thrown the matter back to Nigeria because Ghanaian conflict rules apply lex domicili and the couple are domicile in Nigeria. So Ghana on its own has said, ignore our law, apply the lex domicili. And based on Ghanaian conflict, we are going to apply the lex domicili. And the lex domicili, if the couple are domicile in Nigeria, then we end up using Nigerian law to determine the question. Okay? So we have partially accepted Ruvua. Okay? Now, when you are talking about partial Ruvua, it is of two types. It could be by remission or by transmission. It could be by remission or by transmission. What do we mean that it is partial Ruvua by remission? What we mean is that the conflict rules of the lex conciliar will direct the matter back to the forum. And the forum will therefore apply our own law. What has happened is that there has been partial Ruvua by remission. But suppose in the facts we have given, the couple are not even domicile in Nigeria. They are not domicile in Ghana. They are domicile in the Republic. What are we going to do? We are going to apply the Republic law to determine the question of the formal validity of their marriage. Why are we doing that? We are doing that because we are following the conflict rules of Ghana, the lex conciliar. So what we have done is we have done partial Ruvua by transmission, not by remission, because we are not applying the forum law. We are applying the law of a third country, which the conflict rules of the lex conciliar have directed us to apply. Is it clear? Is it clear? Can somebody explain to us
Yes,
what
sir.
we mean
Yes, sir.
by
It's clear, sir.
partial Ruvua by remission, partial Ruvua by transmission? I think I should not treat you people like undergraduate now. You have understood. So let's go to the elephant in the house. Total revoir. The one we call total revoir or double revoir. This one has many orikis. One of the orikis of this one is what is called foreign law theory. Sorry, foreign court theory. Foreign court theory. Foreign court theory. Conflict of laws experts explain foreign court theory to mean that, look, this case is going on in Ikeja High Court. Pretend that it is not going on in Ikeja High Court. If the lex concierge is Ghana, pretend that the case is going on in Ghana. So what is the implication of that? The implication of that is that you are not only going to apply the conflict rules of Ghana, you are going to apply the revoir concept of Ghana. You are not going to confine yourself to the conflict rule of Ghana. Partial revoir confines itself to the conflict rules of the lex concierge. But total revoir will say, no, conflict rule is not enough. Revoir concept. It is the revoir concept of Ghana that you apply. And that is why it is said that it's as if you are lifting the case, lock, stock, and barrel, and situating the court in Ghana. So when that happens, partial revoir is not enough. You need to know the revoir concept of the lex concierge. And it is the revoir concept of the lex concierge that you will apply. It is the revoir concept of the lex concierge that you will apply. Okay? So switch your whole intellect into logic and mathematics, and you will understand what we are saying. Let's give an example. Benin Republic is a civil law country. So the Republic conflict rule is in the area of personal law generally. Their conflict rule is law of nationality. They will apply the law of nationality of the propositors. But Nigeria, as a common law country, will not apply the law of nationality of the propositors to apply the law of domicile of the propositors. So the Lagos High Court is to determine who is entitled to inherit the property of a Nigerian citizen domiciled in Benin Republic. The movable property of a Nigerian citizen domiciled in Benin Republic up to the point of death. Okay? So our presenters, what is the connecting factor? Nigerian court, what is the connecting factor for succession to movables? Answer. It's an objective question now. Oh yeah. What is the connecting factor for succession to movables? Hello? Hello?
So it's the lex loci domicile.
Hello, sir.
Yes. What is the connecting factor where the issue is succession to movables? Succession, intestate succession to movables.
Lex loci domicile.
Lex domicile. And we said the person is a Nigerian citizen, but is domiciled in Benin Republic. So it means that we are talking about Benin Republic law. Is that not so? Is that not so?
Yes.
Yes, sir. Yes, sir.
Good. Very good. Suppose Nigerian rural concept is internal law theory. What is the meaning of Benin Republic law in that context? Yes?
Please come again, sir.
Suppose Nigerian own concept of RUVA is rejecting RUVA or internal law theory. What is the Lagos High Court going to do?
And the person is domiciled where, sir? It will be where the person is.
We said when we were setting the question, we told you that the person is a Nigerian citizen, but his domicile in Benin Republic up to the point of death.
If we are rejecting RUVA, sir, it will be the internal law of Nigeria. The person is a Nigerian. High Court. It's Nigerian law that will apply, sir.
You don't understand it means I've been talking in vain all this while.
No,
How
sir.
can you say so? If
Please,
we are
sir,
rejecting RUVA,
okay.
What law will Lagos High Court apply?
So if we're rejecting RUVA, it means that the Lagos High Court will apply the law of the internal law of Benin Republic, which is the law of domicile.
Yes, that's the correct answer. Now,
Thank you, sir.
if we are accepting RUVA, okay, what first inquiry will the court make in order to determine the applicable law? If we are accepting RUVA, what first inquiry will Nigeria court make?
Where the party is domiciled.
The answer, the simple. The Lagos High Court will find out what is the conflict rules of Benin Republic.
Exactly, of the other country.
And we have already told you that Benin Republic applies. What does the Benin Republic do? As a civil law country, what do they do?
They apply the law of nationality.
Expatriate.
Yes, lex patria, the law of nationality. So which means that a court sitting in Benin in the circumstance would be willing to apply Nigerian law as the national law of the propositors. Okay.
Anything anybody do, make una dey do, but more than they remember say tomorrow day.
Sorry, I'm doing this lecture at home, and women are disturbing my life. Okay, so are we getting it?
Yes, sir.
Yes, sir.
So the Lagos High Court cannot arrive at an answer without finding out what the complete rule of Benin Republic is. And the complete rule of Benin Republic in this type of event is the law of nationality, which means that Beninese conflict rule will refer the matter back to us because the propositors was a Nigerian citizen, and Beninese conflict rule will apply national law and not domiciliary law. So they will refer the matter back to us. And if our removal concept is partial removal, we will go ahead and apply Nigerian law on the excuse that that is what Ghanaian conflict rules has directed us to do. And that will amount to partial removal by remission. Now, suppose the propositors was a Ghanaian. Suppose he was a Ghanaian. And our own removal concept is partial removal. Who can tell me what law we are going to apply? Hello? Who can tell me what law we are going to apply in that circumstance? Our removal concept is partial removal. The propositors lie domicile in Benin Republic, though he was a national of Ghana, but somehow, maybe his Nigerian relations have brought the matter to court because they think they are the ones who are entitled to have a larger share of his estate. Okay? So, Beninese conflict rule, nationality. Nigerian conflict rule, domicile. The propositors, Ghanaian national, Beninese domiciliary, with family members in Nigeria. So you are presiding over the matter in Lagos High Court. Which law? Assuming Nigerian removal concept is partial removal, which law will you end up applying to determine distribution of the estate of the deceased?
Double removal by transmission.
It will be
No, by
removal by
remission.
transmission.
By
So you
remission.
are going to apply Ghanaian law. Is that not so?
Yes, sir.
Good, very good. Now, assuming Nigerian removal concept is double or total removal, or what is known as foreign court theory, what are you going to do? What did I say you will do if you are applying double removal? What did I say you will do? What is the inquiry that the judge will make if the removal concept is total removal? What is the inquiry that he must make?
To find out the removal concept.
Yes, you find
country.
out the removal concept of let's consider. That is what is the let's consider in our context? Benin Republic. Or pretend that the case, even though it's going on in Ikeja, is actually going on in Benin Republic. Put yourself in the position of the Benin judge. The Benin judge will apply the removal concept of Benin Republic. So it is the removal concept of Benin Republic that you will ask. You are not going to be contented with asking for the conflict rule of Benin Republic. You will ask removal concept of Benin Republic. Okay? So, again, Benin Republic may have any of the three removal concepts. It may have internal law theory. It may have partial removal. And it may have total removal. So let's go. Suppose Benin Republic's removal concept is internal law theory. What law will the court apply?
The laws of Benin
Remember
Republic.
that Benin law is, Benin conflict rule is law of nationality. And Benin removal concept is internal law theory. The case is going on in Ikeja. Nigerian conflict rule says apply the law of the place of domicile. And by Nigerian rules of domicile, the man was domiciled in Benin Republic, though a Nigerian. Beninese conflict rule says apply law of nationality. Beninese Ruva concept says internal law theory. What law will the Kenya High Court end up applying to distribute the estate of the deceased?
Local or internal theory of Benin Republic.
What?
Local theory of Benin Republic.
What do you mean by local law of Benin? Why will they apply local law of Benin Republic? It's simple arithmetic now. You just do as the Benin court will do. Suppose the case was going on in Benin and the deceased was a Nigerian citizen, though domicile in Benin Republic. Benin will apply a conflict rule, which is lex patria. And because Benin's Ruva concept is internal law theory, it will apply the internal law of the lex patria. So that means it is the Nigerian local law that the Kenya High Court will end up applying. Do you understand the arithmetic?
Yes, sir.
Okay. Now let's go to the second possibility. Suppose Beninese conflict rule, suppose Beninese Ruva concept is partial Ruva. Tell me what law the Nigerian court will end up applying. Answer now.
Partial rule by remission.
Yes, partial Ruva by remission, that is, we say that is the theory in Benin Republic, but the case is going on in Nigeria. So which internal law will Nigeria apply if Beninese Ruva concept is partial Ruva, whether by remission or transmission? If Beninese Ruva concept is partial Ruva, which law will a Nigerian court end up applying in that case?
High Court laws of Lagos State.
We are not talking about procedure now. They will end up applying Nigerian law.
Nigerian law, sir.
They will end up applying Nigerian law. Why? Why would they end up applying Nigerian law? It's very simple. You have lifted the court, lock, stock, and barrel. The case, lock, stock, and barrel, and situated in Benin Republic. So the Benin court will ask itself, this is a matter of succession to movable. We apply lex patria. Lex patria is, sorry, your answer is even wrong. We apply lex patria, but look at the working. It's like mathematics. You may get the answer wrong, but if you do the working correctly, you will still earn a mark. Okay? The case is going on in Nigeria. Double Ruva simply says, pretend that the case is going on in Ghana. So if the case is going on in Ghana, pretend that the case is going on in Benin Republic. If the case is going on in Benin Republic, the Benin Republic court will apply lex patria, which will direct it to Nigeria, which is the nationality of the propositors. Okay? Upon finding that Nigerian conflict rules will direct the matter back to Benin Republic, a Benin court will accept that remission. So a Benin court will end up applying Beninese law if Benin Ruva concept is partial Ruva. So, and that is what a Nigerian court would do if Nigerian Ruva concept is double Ruva. Because what we are doing under double Ruva is where we are lifting the cost, lock, stock, and barrel, and situating it in the less concerned. So contrary to what you said, what a court in Ikeja would do, where we are applying double rover, and the Beninese rover concept is partial rover, a court in Nigeria will end up applying Beninese law, because that is what a court in Benin will do if the case were to go on in Benin. So that is the implication. In summary, internal law theory simply means applying the internal law of the lex concern or rejecting rover. Partial rover simply means applying the company rules of the lex concern, and if it means remitting the case back to you or transmitting it to a third country, apply the internal law of your own country or the internal law of that third country. But double rover simply means apply not only the conflict rule of the lex concern, apply also the rover concept of the lex concern. Otherwise explained as lift the case, lock, stock, and barrel, and situate it in the lex concern, and do exactly as the lex concern would do. The court of the lex concern would not only apply its conflict rule, it will also apply its rover concept. So a combination of those two is what you are going to do. You are going to apply the conflict rule and the rover concept of the lex concern, not your own. That is when you are said to have applied double rover in your own country. So that is the different concept of rover we have. The next stage is, which is our own rover concept. The undergraduates, we will teach them this first part. And because we don't want them to be confused, we will not teach the second part. The second part of it is, which one can we say our own courts have been doing? Is it that they have been applying, they have been rejecting rover by applying the internal law of the lex concern? Or is it that they have been partially accepting rover by applying our own internal law when the complete rules of the lex concern remit the matter to us, or the internal law of a third country when the complete rules of the lex concern transmit the matter to them? Or is it that they have been applying not only the conflict rules of the lex concern, they have been applying it together with its rover concept, which is what we mean by double rover. So that is the next stage. And that one is a very, very difficult task. There are usually a number of cases that you look at. Okay? At the time the courts were deciding the cases, they didn't know all of these concepts. All of these concepts of so I hope you have understood me up to this stage. Hello? Hello?
Hello,
one.
sir.
Hello, sir.
Are you people still hearing me?
Yes, sir.
Yes, sir.
I said you have understood up to this stage. You know the difference between internal law theory or rejecting Ruva. You know what it means to say you are accepting Ruva partially, either by remission or transmission. And you know what you mean when you talk about double Ruva. When you say what you are doing is you are doing total Ruva or double Ruva or foreign court theory.
Yes, sir.
Okay. So the next stage is, which one have we been doing? What is Nigeria? What is Anglo-Nigerian Ruva concept? Which one is it? Is it internal law theory? Is it partial Ruva by remission or transmission? Or is it double Ruva? So what we have to do under this head is look at some cases that textbooks will give us to illustrate whatever their opinion is. Whether their opinion is that we have been doing double Ruva and look at this and these cases and all of that. So I'm going to refer you to a basic text. And if we have time, we now look at which of the three different Ruva concepts can we really say that our own courts, that is the English and Nigerian courts, have been following. Okay? I'm going to end this class earlier than necessary. One, I'm tired. Two, there's still good time. Oh. It's just 80 minutes after 6. Okay, just wait for me. Let me sign some documents. Okay, can you hear? Actually, I don't mean to replace. Hello, fún wa náà, Professor méjèèjì. Okay. I do now. So now we are going to look at the cases that text writers will usually analyze. This is a topic that Professor Agbede has written on. I think it's maybe chapter 2 or 3 of his book. So if you have Professor Agbede's book, you can look at his treatment of this topic. But I'm using the cases presented by Morris for his usual position that what the English court do is total Ruva. total revoir. He gave in saying that the English position is total revoir, he used two cases. The first case is the case of Annesley. Annesley. I hope you are hearing me. In Annesley, T, a British subject of English domicile of origin, died domicile in France in the English sense, but not in the French sense. What we are saying is that English company rules will assume that he died domicile in France, but French company rule will not agree that he died domicile in France. Okay? So he was a British subject. He had an English domicile of origin, but by the English concept of domicile, he is deemed to have acquired a French domicile of choice. So she, not he, she left a will that purported to dispose of all her property. By French law, she could only dispose 1/3 of her property because she had left 2 surviving children. Evidence was given that the French court will refer to English law as this national law and will accept the removal back to French law. French domestic law was applied, and this will was only effective to dispose of 1/3 of our property. Did Morris make out a case for double revoir or not? When you are looking at this topic, you must wear the cap of a mathematician or a person who applies logic. Let's go over the facts again, honestly. It looks like the example I've given of Benin Republic. T was a British subject. She also had an English domicile of origin. Okay? She died domicile in France, in the English sense. In other words, the English concept of domicile will agree that she has acquired a domicile of choice in France. So she died domicile in France according to English concept of domicile. Even though France may not agree. But whether France agrees or not, France, like our Beninese example, will not apply domicile to determine inheritance. France will apply what? Nationality to determine inheritance. So, there are fundamental differences between English and French law as it regards to capacity to make a will. English law permits a testator to make a will in respect of all his property, irrespective of whether he had a wife or children. But French law, like customary law, Islamic law, will not permit you to make a will. Okay, will not permit you to make a will to the exclusion of those who are your primary heirs. So the deceased that died survived by 2 children. And by French internal law, any will she makes to cover more than 1/3 of her property will be a nullity. Because she had obligation to provide for the two surviving children. So the question before the English court is the validity of the will. If the will is governed by the law of the place of domicile, then the will is supposed to be governed by French law. But what is the meaning of French law in the context? If it meant French internal law, the answer would have been French law, French internal law. If it meant French conflict rules, if it meant French conflict rules, that is acceptance of Louvois partially, the English court would have ended up applying English law. Do you understand? Hello?
Yes, sir.
Yes, sir.
English court would have ended up applying English law. But because the English concept is double Louvois, what the English court will do is exactly what the French court will do. Okay? So the English court ended up applying the French Louvois concepts together with conflict rules. That is, the French court sitting in France would apply lex patrie. It would then find that English law is the lex patrie. Upon discovering that English law will remit the matter back to them as the lex domicile, French court would accept. So because French court will accept, that is French Louvois concept is partial Louvois, English court ended up doing what the French court would do and apply French law to invalidate the will. That's the case of the annexary. So when we say Anglo-Nigerian position is total Louvois, you will cite the annexary to support our position. Okay? But let's see what happened in the Ross. Let's see what happened in the Ross. A British subject, domiciled in Italy, died leaving movables in England and Italy, and the movables in Italy. She left two wills, one in English and the other in Italian. By her English will, she gave her property in England to her niece, X. By her Italian will, she gave her property in Italy to her grandnephew, Y, subject to a love interest to his mother, X. She left nothing to her only son, Z. Z claimed that by Italian law, he was entitled to one half of this property as his legitimate potential. That's the internal law of Italy. By the English company rules, the validity of this will was governed by Italian law as the law of our domicile in respect of movables, and by Italian law as the lex situs in respect of immovables. Evidence was given that an Italian court will refer to English law as this national law in respect of both movables and immovables, and will not accept the Louvois back to Italian law. You see, just get the gist. I told you that when you are applying double Louvois, you must make two inquiries. What are the two inquiries? One, the conflict rule of the lex quotient. Two, the Louvois concept of the lex quotient. So look at what happened in this case now. In the Ross, the English court needed not only the conflict rule of Italy, the lex quotient, which is lex patrie, remitting the matter back to England, but it also asks itself, what is the Louvois concept of Italy? And it says, Italy will not accept Rouvoir by transmission or by remission. So which means that Italian Rouvoir concept is what? What is Italian Rouvoir concept? Hello?
It's total reverse.
No, Italian Rouvoir concept is internal law theory. The fact says they discovered that Italian law does not accept Rouvoir. That's rejecting Rouvoir. So which means that once Italian law determines by its conflict rules the applicable law, it will apply the internal law of the lex corsia. So what did English court do? English domestic law was applied and Z's claim was rejected. So if Murray said on the basis of the Ross that English Rouvoir concept is double Rouvoir, is it right or wrong? Hello? Is it right or wrong?
You'd be right, sir.
He's right. He's right. All you need to do is put yourself in a mathematics and logic mode. Once you do that, you'll be able to understand why Morris is correct to say if we are to follow decisions like Rhea and Nestle or Ross, it is very easy for us to say that yes, the Rouvoir concept of England and by implication Nigeria, we are follow, we never have our own, is double Rouvoir. Okay? Just 2 cases. There are many other cases, but I don't want to bore you. I don't want to bore you. Let me leave you with those 2 cases. You can read. Agbede to see his critique of the common law position. Okay? You can read him to see his critique of common law position. But the most important thing is for you to understand what we mean by Rouvoir, what are the different theories of Rouvoir, why do we say that the Anglo-Nigerian position is double Rouvoir? Okay? You will do well if you look at other cases in line with Nestle and Ross. And if you want to disagree, you will do well to see cases that have been analyzed to arrive at a different conclusion. On that note, we are already very well behind schedule. Let us say we have ended the discussion on technique. Next week, we are going to take 2 papers because time is running against us. We are going to take the topic of exclusion of otherwise applicable foreign law and the topic of connecting factor for personal law, comparing domicile with nationality and habitual residence. It's an ambitious program, but let's see if we can finish one of the 2. But let's for now say we want to take the 2 within the 2 hours of next lecture. Okay? Are the papers on those 2 topics ready? Hello?
Yes, sir.
Let's have the papers so that we can go over them before the date.
Okay,
30 minutes of presentation, 30 minutes of discussion. It's an ambitious task we have set for ourselves. But let's see how it goes. So on that note, I'll see you next week. Or is there any question? Before I end the lecture, is there any question?
Sir, the
Hello?
questions are numerous, sir. But we would read it again then maybe next week. Sir, I don't know, Mass. This one is a little bit strange, sir.
Don't ask me. If you don't ask me question, be ready for my question in the exam. Okay?
We will ask you next week, sir. Please.
Okay. So see you next week.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Hey, Mary, how are you?